to one and all present here. I, Takshama Maheshwari, on behalf of Legal File, welcome you all in this prestigious panel discussion where today we are celebrating the 72nd Republic Day. A very happy Republic Day to all of you. It is the day on which India's constitution was adopted in 1950, following the country's independence on August 15, 1947. In the honor of India's 72nd Republic Day, today we are having an enlightening panel discussion to better comprehend the relevance of changes in the constitution, as well as the goals and the values that it represents in the current situations. We'll talk about how the Constitution has evolved as the most essential document over the last 7 decades. We are thankful to all the panelists for joining us today on this auspicious occasion. So, today we have with us our first panelist, Ms. Pallavi Pratap. She is the managing partner with Pratap & Co. She is the advocate on record in Honorable Supreme Court of India and practices in Supreme Court, various high courts, tribunals, NCLT, NCLAT, NCDRC, etc. We are grateful to have you with us today, ma'am.
Thank you, Takshima, for having me here. I can see the grin on my dear friend Swanindu's face when certain things were said, and I'm so happy that he actually was instrumental in inviting all of us here today. Thank you, Damini, for having me here, and I hope all of you have had the occasion of enjoying the parade and was able to see whatever it was in terms of the tableaus that came. Um, I'm just very excited that we've actually all gathered here together to speak about certain questions that as practicing advocates and also law aspirants we've been sometimes forced to ask. So I really look forward to the panel discussion today, and Takshima, you can proceed with introducing everybody else.
Sure, ma'am. Thank you so much. Our second panelist is Mr. Swardindu Chatterjee. He graduated from KIIT University, Bhubaneswar. He was managing associate at Luthra and Luthra, and now he is the managing associate at Saraf and Partners. Thank you, sir, for sparing your time for this session.
Thank you, Damini. Thank you, Dakshima. First of all, I'm the principal associate, not the managing associate. This is
Sure,
a
sir.
small correction. One, although the terms are coterminous, but this is one thing which I wanted to correct. This is one. Second, you see, this is one of the most important deeds of our legal system, rather of our lives. It's the 73rd Republic Day and the Constitution since the Constitution came into force. And it's one of the most dynamic documents you will find all over the world, comparing all other constitutions. And it has adapted to so many changes, yet it is alive. We would have we have witnessed so many downfalls in the constitutions of all other countries, many other countries rather, which have reenacted the constitution according to the changes. But the constitution which was drafted by our constituent assembly, by our esteemed forefathers and all founding fathers of the constitution, they were so far sighted that they made a dynamic document and drafted a dynamic document which could adapt to the changes we would have had and we would have in the past 73 years, in the coming 100 years or so. Thank you for inviting me.
Thank you so much, sir. Our third panelist is Dr. Daksha Sharma. She is an assistant professor, law, School of Law, Bennett University, Times of India Group. Apart from other publications and research experiences she has co-authored Advocate Salman Khurshid. The name of the paper is Spectrum Politics, Unveiling the Defense. She has also been awarded with Dr. Sarojini Naidu International Award for Working Women 2021. We are grateful to have you here, ma'am.
Thank you, Takshima, and thank you, Damini, and all other organizers for having me here. It's indeed my privilege to share my views and opinions on the working of Indian Constitution because in the present semester I am taking constitutional law lectures. So it is indeed a pleasure and privilege at the same time for me to hear from the eminent advocates of the Supreme Court who are present in the same panel. Thank you very much.
Thank you, ma'am. Lastly, we have with us Miss Akriti Chaube. She is an independent litigating professional specializing in Supreme Court litigation and arbitration. She has over 9 years of experience in litigation as well as investment treaty arbitration. She has managed litigation in several landmark cases before the Supreme Court of India, such as Ayodhya dispute, the entry tax matter, the triple talaq matter, etc. Thank you so much, ma'am, for joining us today.
Thank you very much. As everyone has already made it very clear that constitution plays a very, very important part, in our lives. Especially being lawyers, there would have been, I mean, half of our livelihood would have gone if not for the constitution. And thank you so much to Swarnendu as well as the organizers for making this happen. All of these people are so eminent, and I'm meeting most of them for the first time, but they've been so warm, and it doesn't feel like it's the first time. And I'll just tell you a personal story. Constitution in my life, personally, it has played a very instrumental role in the sense that when I was starting my own chamber, Dr. Rajiv Dhawan had gifted me this preamble, which you can see on the back of my chair. And so and he told me whenever you open your chamber, you must put it there. And so you can see that it's there. And I'm really happy to be here and a part of this discussion.
Thank you, ma'am. Now I would request Damini to take over.
Thank you so much, Takshima, and wishing you all a very happy Republic Day. So, without taking up much time, I think we should start with our panel discussion. So, my first question is for Advocate Pallavi Pratap that, ma'am, whenever we talk about Constitution, we talk about the amendments that have been, done so far. We talk about the basic structure doctrine. But do you really think that after around, having more than 105 amendments in our Constitution, we have been able to follow the ideals of the basic structure doctrine, or do you feel that it has been violated a bit? So, what do you say on this regard?
See, that's a tough question, Damini, of course, because as practicing advocates, we typically try and um, abide by every single word that the Constitution has laid down. It's like you see Akriti having it framed right behind her and being given by someone like Dr. Dhawan. I think it's a huge it bears a lot of meaning. um, Having said that, I feel when you look at the basic structure doctrine and the evolution that has happened so far in terms of the amendments and therefore the constitution sort of changing with each amendment, I think that makes it that kind of shows that how the society is changing, and therefore we are also changing and the laws are also changing per se. I mean, if you look at it, we've been recently we've been seeing a lot of debate around the marriage age being increased to 21, and therefore the parallels being drawn to Article 14, and then a lot of other discussions that come in with amendments when they happen in criminal law or any of these. And when you see the ancillary laws or the other statutes actually getting amended, you see that the first question that comes in is that is it challenging the fundamental right, or is it that we are seeing that some in some form the fundamental right of a person is getting abused. And then that whole debate starts to happen. That's the beauty of democracy, I feel, and that's the beauty of our system, that in parliament we've seen that not very far from now, we've seen in past couple of months bills which were thought to be completely abrogating the fundamental rights of individuals have been done away with. So it is not that the voice of the common man is not heard, it is definitely heard. But when you look at it vis-a-vis basic structure, you ask yourself this question, that is it is it really that when these bills are being bought or these amendments are being bought, are they really questioning, or are they actually challenging our fundamental rights? And to large extent the answer is yes. A lot of these amendments that happen, or a lot of these interestingly ordinances which have come in the in latest I would say past 2 3 years, we've noticed that there has been significant challenges in terms of our fundamental rights. And that, of course, as we know, forms the part of the basic structure doctrine also. But we've also seen that when the citizens come out and say that no, this is not right, this is against what we believe to be the part or the essence of the constitution, or of the essence of our rights, I think the legislature actually understands it. However, to cut a long story short, I feel when you look at the question that you've asked, we have traveled a lot. We are still a very young nation. I mean, if we compare other nations and look at their constitution, and for us, it's only been about 70 odd years. The evolution is still going to happen with the kind of technology that is coming in, the kind of new ways of exploitation also which is coming in. I think we will see a lot of evolution that will happen as far as our constitution is concerned. And at the same time, we will see that and this is not just a phenomena which is here in India, it is there globally now, that we see that there are attempts which are made to violate the fundamental rights of individuals. It could be by the legislature, it could be sometimes that they are actually traveling beyond what they should have actually been observing. However, we've always noticed that just as every right comes with its reasonable restriction, we see that when such laws are brought about, like for instance the farmers bill very recently, we've seen that when such bills or attempts are being made to in some manner shake the basic structure, I think people do rise up, and that definitely has an impact. So I think the checks and balances are very strong as far as our nation goes. And I think as citizens, all of us understand our rights and understand as to where we have to rise for others to make sure that their rights are not being challenged. So I think that's my answer to it, Damni.
Thank you for the response, ma'am. But I would like to ask Advocate Akriti if she would like to add on to this question.
Thank you. So, basic structure doctrine, as we all know, that initially it was brought about only to sort of challenge, ensure that none of the only to check the constitutional amendments, that none of the constitutional amendments are so perverse that they go beyond what the founding fathers envisaged for our country. But then now, I mean, in the recent judgment, I think in Kuldeep Nayar's judgment, the Supreme Court had said that it doesn't apply to the the ordinary legislations. Basic structure doctrine will not apply to. However, now with the NJAC judgment, it has been very clear that even ordinary legislations now you can challenge them on the ground of the basic structure doctrine. So definite. I mean, I feel that obviously, as Pallavi said, I completely agree with her that there has not been a dilution, so to say, of the basic structures, and we have sort of come what may, either by the judiciary or by the legislature, listening to the people has kind of maintained that the basic principles of our constitution. However, I feel that extending the basic structure doctrine to ordinary legislations, I think that's a bit of an overreach. That's what I feel.
Okay, so the next question is for Swarnendu, sir. Sir, we have seen that nowadays people, apart from going to courts, they prefer arbitration, mediation, or any other sort of, dispute resolution mechanism that is there. And I think these sort of mechanisms are emerging nowadays. So, do you really think that even our constitution has actually prescribed this idea? Because when we talk about arbitration, conciliation, mediation, people don't talk about constitution at all. So what would you say about this? That really constitution prescribe these sort of mechanisms?
You see, a very good, very pertinent question. Nowadays, even judges promote pre-litigation mediation. The bill is pending in Parliament, and there are certain classes of. In fact, if you see Section 6 of the bill, it says that it prescribes 5 and 6. It prescribes certain classes of disputes which can be referred to pre-mediation litigation. Now, when constitution was framed and brought into force, like when you see our constitution, there is one part, like as my late senior used to say, there is one part which is pre 1973 and there is one part which is post 1973. The evolution is always in parts, and as I said as I told everyone in the beginning, it's a dynamic document. It has to adapt to changes. Now, with 130 billion people, 130 crore basically, so much population, the courts are overburdened with litigation. We as lawyers know how much we have to fight to get a matter heard, let alone be heard, be listed. The matters we have to fight day in and day out for matters, to get matters listed in time, because to every client their matter is super urgent, extremely urgent. No client will come and tell you, no, no, my matter can wait for 6 months or 12 or a year. Everybody wants an interim order or an order upfront, right? For that, when we as lawyers appear, suppose in matters which can be solved through mediation or conciliation, it and every step under every statute ensures a doctrine of fairness. And where from the doctrine of fairness emerges? It emerges from the very essence and spirit of the Constitution. No act, we must all remember, the Constitution is the grand norm. If everybody is aware of Kelson's grand norm, it's the grand norm. No law, it's the paramount law. No law can abridge the four pillars of Constitution. One of the strongest pillars being doctrine of fairness. Now, in mediation, both equities are well balanced. In conciliation, are well balanced. It is within the constitutional sphere only these alternative methods of litigation are there, where problems are solved outside the court, so that the court's time and value for money is not given a watershed, and it is given true purport and value, and matters get solved when it comes to the court. Okay, matters solved, closed. So both parties have their own equities in place. Nobody wins or loses. Both parties agree to something, like you see in matrimonial matters, you see in this in sometimes uh, in construction matters, in in other disputes where we go for section 9, we go for a petition under section 9 of arbitration. So basically most of them are economic, have an economic value attached to it, right? Even for proceedings under IBC, they have economic value attached to it. That is why government has come up with pre-packaged insolvency. So like, you have to balance the economy, balance the equity, balance the rights of the people qua a legislation. So therefore there is, like, it may not be particularly inscribed in as a article in the constitution, but yes, legal representation, legal representation, pursue your legal remedies, those are a part of our fundamental rights. And all of us are treated equally before a court of law. Those, that rule of law, that sense in our mind that okay, we'll get justice, somewhat justice. And if we go to the court and sit across a table, even on mediation, then our problems might get solved. That hope comes from the very essence and pillars of the constitution. If there was no constitution, there would have been no constitutionalism. And because there is constitutionalism, the legislations exist. This is my answer to this question.
Thank you so much for your response, sir. So the very next question is for Professor Daksha. So, ma'am, what is the one issue that you would really like to highlight and that really needs to be resolved?
With respect to the Constitution of India. Okay, so thank you, Damini, for this question. I would like to say here that if we see the working of Indian Constitution, it is more or less a dynamic process. Our constitution is something which is a progressive document. 104 amendments have been taken place so far, which shows that it is working with flexibility as well as rigidity at the same point of time. uh, when we talk about few more aspects dealing with UCC, that is Uniform Civil Code, so that is one area I feel that really needs attention of the lawmakers, because UCC, if we see the concept, it is it is not an age old concept. Since the inception of the constitution, it has been realized that there is a need for a UCC, Uniform Civil Code, and that is why we have the directive in place, that is Article 44 of the constitution. In fact, in the same regard, we have codification of the laws, especially Hindu laws. When we talk about Hindu Succession Act or Hindu Marriage Act, this is nothing but this is something which is in direction towards Uniform Civil Code. There are landmark judgments relating to UCC. If we see Sarla Mudgal's case, then Shah Banu's case, 1985, and then recently, if we talk about adoption laws, we have Shabnam Hashmi's case in the year 2014. So it shows that judicial activism is also one major step which is responsible for directing the progression of the constitution in the right channel. Furthermore, I would again like to highlight here that though directly we cannot say that UCC is in place, but there are efforts which are made for modernizing our legislations, which is of course the need of the time and need of the society also. For instance, if we talk about Juvenile Justice Care of Children and Protection Act 2015, if we read the structure, if we read the content of this statute, we would come to the conclusion that this legislation is not religion specific. This legislation is applicable to the people of all the religions. So I would again say that this is one of the progressive and the modernistic approach by which this particular legislation has been drafted. This is a way towards uniform civil code in India, and such matters should be resolved at the earliest, because we have to live up to the spirit of the Indian Constitution, and the very spirit of the Indian Constitution is present in the preamble of the Constitution, which talks about the principles of justice, liberty, equality, fraternity, unity, and integrity of the nation. So, of course, when we talk about these ideals, these should not be mere ideals which are mentioned in the preamble, but this is something which should be penetrated deep down within the psyche of every individual, every citizen who is the part of the country. So, that's what I believe, that this is one particular area where we need corrections at the earliest. So, thank you.
Thank you for your response, ma'am. So now I'm going back to Advocate Pallavi. So, ma'am, I have a very important question for you, because I've seen you, talking about this issue very often. That we have seen a lot of amendments with respect to, that talks about equality between men and women. And from the last 72 years, we have seen so many amendments in various statutes that talks about, in support of women, to provide them and to achieve equality, to provide them justice. So, do you really think that these amendments were actually a sort of successful in their own way to provide equality between men and women? And were these amendments like okay to achieve this sort of equality and to provide fair and justice to the women?
That's a very interesting question, Damini. Okay, the answer to it is that actually there's no correct answer to it. The point is that we are still a very young nation. We are just about 70, 72, 75 years. I mean, whichever way you want to calculate it. And there is a huge burden of patriarchal mindset that we have in our society, which I think is very difficult for any one of us to break through or to shatter it, right? I mean, for instance, today Swarnendu was the one who's got all of us together over here. This happens to be an equal participation, maybe too much of a women participation, less of a man's participation, but nonetheless here we are, that we've all been looking at it and being treated equally. But this is when we are actually, most of us are in the capital of the country. We all practice in the top court of the country. But if we just move about 20 kilometers off here, from here to Sonipat, or to Ghaziabad, or any of these places, and then further down to, let's say, 1,000 kilometers, we'll see that the disparity is huge. So why is it that these amendments are being brought about in order to make sure that women are uplifted? It is because the state feels that if there are laws, then people will abide by it. And if for instance there are not 100 such incidents, at least some of those incidents will not, if not the 100 of those incidents will get resolved, at least 20% of them will get resolved. Like for instance, we've been debating a lot about the age being increased to 21, and there are pros and cons of it. We all see that there is a debate that no, people who are not aware of this law, which is basically people in backward districts of the country, they will unnecessarily be penalized because they are not aware, they still feel that it is 18 years of age, or the conditions are such that they want their daughters to be married off quickly because they are worried about um, any sort of sexual offenses being conducted against them. So these are very valid problems that people face, that we obviously, being more privileged, are not so we are not so exposed to it. However, I still feel that every single amendment that is done, with its pros and cons, is actually a step which is in furtherance to for I think for most women, if not all, for most women. Why? Because I feel personally that every time one of us, one of the women, is actually moving forward, we are actually motivating about 100 others who are right behind us, who look at us and move forward. Like for instance, Akriti has her own chamber, or Dr. Daksha is a professor. What happens is that women see that, okay, someone's achieved something like this, and they feel motivated, and they have that they can dream. And I think that's how the dreams actually become a reality. So that sort of is, I think, that's how we are making that progression. We've come a very long way. I mean, for instance, uh, I became a practicing advocate because I read an autobiography by Justice Leela Seth. And that was my, what do you call it, so that was a dream that I'd seen many years back, and that's how I went. Now I'm sure there will be people who would probably be looking up to me, or to Akriti, or to Daksha ma'am, or to you guys, in terms of achieving what they want to achieve. So it's just that when one of us moves forward, all of us move forward. And then we should also compliment people like Swarnendu, who actually make an effort to ensure that all of us are walking together. I think a lot of times when we talk about women legislation, we of course there are debates with respect to why in the committee there is just one woman, and everybody else is a man when it comes to the raising of the age. But we also must, I think, compliment the men for also ensuring that for being understanding at times, and to voice for us. So just as we say that equality is for women, equality of course has to be there for men, in that sense, because I think a lot of laws are being misused in that sense. We forget that we have to be humanist first, and not really look at gender specific roles that are attributed. Having said that, I think we still have a very, very long way to go as women. And Akriti will definitely agree with me. We both practice in the Honorable Supreme Court. I think the challenges are quite a lot for litigating lawyers, people who are independent professionals. I think it is extremely challenging with the lockdown also, which has happened. To get to be able to work, and to be able to generate work for people who are dependent upon us for their livelihood. I think that's a huge challenge that we wake up with every morning and go to bed with. But nonetheless, I think whatever we are doing in our own little way, I think we are paving way for a lot of other women to take it forward. I hope it helps. I really hope.
Thank you for your response, ma'am. But I think now I should ask this question to Swanendu sir as well. So would you like to add on to what ma'am has just said?
Like as I always say, both these women, Akriti and Pallavi, have been an inspiration for many men who are taking up the legal profession. If you see Pallavi's followers, Pallavi has more number of followers than a male AOR would have actually had. You see, that's not a joke. I have seen Pallavi grow in the profession from day one till date. And if you would have seen Pallavi then, and if you see and you are seeing Pallavi now, it's like somebody who has descended from heaven. Like the kind of professional she has grown. I have seen her like I've seen her, and she has, and it's marvelous to see her journey. You should see and take inspiration from that, how a person from being nowhere in the profession comes to a spot comes into the profession, manages to crack the toughest bar exam, if not Asia, then definitely India, right? And paving a way for so many people, and inspiring so many people, teaching so many people, and taking up matters, like giving people opportunities, and also understanding the correct perspective of the law and acting towards the development of it, not just within the four corners of the courtroom, but beyond. And same goes with Akriti. She, like you see, she has been part of the Ayodhya matter. Ayodhya matter had so many volumes and volumes of evidences only. And it is not it is a teamwork, and every single member of the team has to be accredited, whether this side or that side. Sides don't matter, because as my late senior would have said, it's never an advocate who wins or loses, it's the client who wins and loses. We are there to represent the client, and the faith that a client reposes in us is of paramount nature. And you see these two women today, Pallavi and Akriti. You see, within 10 years or 12 years or 13 years of profession, and within 5 6 years of being an AOR, they have carved a niche. And actually speaking, if you ask them, and we always speak of glass ceilings, wooden ceilings, iron ceilings, and all sorts of ceilings in life. Those are all in the mind. Those are not actual in the. If you work hard, you can be the next Indu Malhotra. And if you don't work hard, you have thousands of excuses to give. Like the paramount excuse today in today's world is mainly by many students, which is somewhat true, that if we are not nationals, we don't get internships. That is somewhat, which is not fully true yet half true, because I can tell you myself, being in such a position, that when you see cover letters, you don't even feel the necessity of opening the CV. Wrong grammar, wrong English, everything wrong in that. And in the CV you write, I watch proceedings. What do you mean by that? So these are like, just because I'm a woman, I'm from a non-national, does not mean that you won't be able to break through. Pallavi is not from a national law school. I am not from a national law school. So, not from a national law school actually does not make much of a difference when you are practicing before courts. We are all designated advocates on record. When Supreme Court takes an advocate on record exam, it does not makes any disparity between, like, say, okay, people from NLUs are automatically AORs. It doesn't make it so. So the ceiling which is there in the mind, it's everything there. And sometimes there are disparities, sometimes there are unequal treatment, but that is because of the traditional, what Pallavi mentioned, that is typically due to the mindset of people. That is due to the typical mindset of certain class of people, which has to change. The change has to come, and the change will come and must come, because you see, even the Supreme Court has so many women judges, so many women lawyers. You walk down the corridors now. So many lady lawyers are practicing before Delhi High Court, Supreme Court, tribunals, and all. So the influx of women into this profession is much more as it was 10, 12, 15 years back. So you have, the groundwork is more, the labor is more. Ask them, they go for conferences at late at night, early in the morning. So those type of excuses, if people, a man can also give, a woman can also give. But if you put behind those excuses and work hard, there is no, there is no, nothing which can stop you from succeeding in life.
Thank you so much for your response, sir. But I would really ask if someone else wants to add on something to this question.
I would just like to thank both of them for singing such high ash. तो मेरे को ऊपर ही चढ़ा दिया है इन्होंने. Really, that's a lot of praise. Thank you so much to digest. And I think Pallavi highlighted one point that we must also credit the men, even if there are. I understand that when women are not on these committees, they tend to get criticized to the highest level, but they are still upholding the rights of the women. I think that is something which is they are not given enough credit for. Even I remember in the triple talaq matter, on the last day of hearing, one of the advocates, I'm not going to name, they told the bench that five men are deciding the fate of women in this country, and they actually struck down triple talaq. They decided in the favor of women. So I mean, that's a sort of credit we must give. And definitely, as Swarnindu said, hard, there is no replacement for hard work. If you work hard, you can achieve anything. But of course, you face challenges. Patriarchy is deeply embedded in the minds of so many people. And I mean, even in the Supreme Court level, many times you work with clerks who feel that, it's I cannot I mean even start to tell you how what harrowing experiences I've had with clerks who always feel that this is not a place where court is not a place for a woman to be. But on the other hand, when I worked hard, and then when they saw that I was getting praised by the seniors, they fell in line. So that's what hard work is, definitely irreplaceable. And if you work hard, then a lot can happen. I mean, inequality is there. That is because womenkind have been suppressed from so long. It's not a new phenomenon. Even the Supreme Court today, I mean, after so many years, we have four women judges. It's a big thing today for the country. It's a big thing in the 21st century. So, I mean, there is still a long way to go, but definitely with hard work, we can persevere and overcome.
Thank you so much, ma'am. So I think the next question is for Professor Daksha. That, ma'am, what are the political ideas according to the preamble that India still needs to secure even after 73 years of this republic?
Okay, as far as the political ideals are concerned, I would again go back to the preamble, because preamble does not direct specifically for politics. It is for all. It is for the working of the constitution. Preamble is the soul of the constitution. So in that, the ideals which are mentioned of justice, liberty, equality, fraternity, unity, and integrity, these are actually required not only in politics but in every domain of the professions. Specifically, like since we were discussing about gender equality, gender biasness. So here, like I would further like to add here that I had a privilege to interact with one of the Supreme Court judges, women judge of the Supreme Court. And while interactions, she just stated that after coming to the position, she was once asked by one of the professionals that what advantage you got as a woman to enter into the judiciary. So I was quite perturbed with her answer. She said that as a woman, I do not get any advantage. The only thing I can mention here is that I got the advantage of being noticed by many as a woman. So, like after hearing her reply, I was quite amazed to learn that her reply was indicative of the fact that the advantage of being noticed she got as a women advocate. And reason being is that there are not many women lawyers in the court, and this is the advantage which women lawyers can get. So apart from that, if we see the concept of equality, yes, it is the concept which very much exists. Like women are not given preference anywhere. If you see in the profession, they are not given preference. So yes, like her answer actually reminds me of the fact that more women participation is needed in the process of lawmaking, in the process of justice dispensation, in other domains also. So women are not lagging behind. What we need is the support from the family. Forget about the neighbors and forget about the society. First, we need the support and motivation from the family. I'm not denying the fact that women are not self motivated individuals. We are, of course, self motivated individuals, but then, yes, certain support should come from the family itself. Now, coming to your question of the ideals which are lying there in the preamble. So, as far as the political system, right, is working here in India, I would say that there should be more absorption of the constitutional principles which are mentioned in the document. And constitution is just not a document. I would be wrong if I mention it just as a document. Constitution is a living document which carries the spirit of the citizens of India. So those ideals should be lived up by the politicians of the country, and that's how the entire scenario in politics can be improvised. So let's suppose, like, when there is any challenge, or when there is any dispute with respect to the provisions relating to equality or provisions relating to liberty, for that matter. So we find that these are, like, sometimes they become religion specific debates, which is actually not needed. So the politicians should also keep this in mind, that their main task, their main duty is to promote the spirit of the constitution. They should work towards promoting harmony and brotherhood in the nation. So if these ideals are promoted in the best possible manner by the lawmakers of the country, by those who are responsible for disseminating the information in the right direction, then I think so that there are possibilities of improvisation in the areas of politics and lawmaking also. Thank you.
Thank you so much for your response, ma'am. But I would really like to ask Advocate Akriti that we have, heard a lot: equality before law, equality in the eyes of law. So, ma'am, would you really like to explain all of us or the people who is going to watch the video on the YouTube, what do you really mean when you say equality in the eyes of law?
So, I mean, equality, you can sometimes people confuse equality with uniformity. So, I mean, that is not what our constitution envisages. Our constitution envisages like treatment for like people. So, Article 14, which, equality is synonymous with Article 14 in India. And that was actually picked up by the 14th Amendment, if I'm not wrong, from the US Constitution. And so, in my opinion, you can, by part, you separate it into three prongs: equality before law, equal protection of law, and access to justice. So the first two I still feel are taken care of, but access to justice is something that India really needs to focus on. Right now, if people cannot afford lawyers, if they can afford lawyers, matters are not getting listed. There is no speedy disposal. Half of the people don't even know that they can actually get legal help, and there are legal aid committees. There is no, I mean, there are legislations, of course, but it for a common man, I think, for me, if today I have to file a case, I will think 100 times before doing it, even being a Supreme Court lawyer. So that goes a long way. I mean, today I cannot afford a lawyer to pay my own legal fees, honestly. So it's a very expensive. So right now, justice is only coming for the rich. It's only coming for the entitled people. For a common man to engage a lawyer, to engage a quality lawyer, it is very difficult. I mean, uh, to approach the court, and if even if to see the battle to its end. Right now, what is happening in India is people are filing cases, as a means to get the other party to settle. You bombard everyone. You don't have the capacity to sustain these litigations. You bombard the other side with litigations, and whoever is the person who has less resources, cannot bombard or cannot defend those cases, he will come down to the settlement table. That's the only thing which is happening right now. So as Swarnendu mentioned in the beginning, that pre-litigation mediation, very important concept, and must be introduced as soon as possible, especially in matters like family matters. You always see, I mean, Pallavi also mentioned that many of these laws are being misused. How are they misused? The lady, ultimately, after filing domestic violence, divorce, she will go and file 498A also, and then in 498A she will file against the in-laws also. And once a person sees that my parents or anyone is getting harassed, he will come to the settlement table, no? So there is no I mean, this is one extreme example, but for a common man to approach, I'll tell you a very similar story. One of my maids, she works in my house help, she works with in my mother's house. So her daughter was found missing one morning. Another guy from the same neighborhood was found missing. She went to file an FIR at least so many times. After at least 4 5 times, she sat the whole day in the police station. Ultimately, they decided to file an FIR. After that, no investigation by the police. Every day they are telling, no, today is Sunday, we can't do anything. Today is Raksha Bandhan, we can't do anything. They did nothing for the longest time. I myself personally went and spoke to the SHO. Nothing happened. Ultimately, we had to, I mean, because I was a lawyer, and I mean, she's been with us for so many years. So we filed a habeas corpus petition, and within 2 weeks they found the daughter. So after the 3 months that got wasted in going to the police station every day, she could have, I mean, because I was there, she could afford to file a petition. But not everyone is so lucky to get access to a lawyer like that. And I mean, it was not rocket science. If they could find the girl within 2 weeks of filing the habeas corpus petition, they could have found her in 2 days when she initially got lost. So that's the way things work. And it's very sometimes it's very demoralizing that you see that your client is being wronged, but the matter is not getting listed. I mean, what do you tell them? Sometimes I really feel coming back from court, I am also myself so distraught. I mean, it affects you seriously, because when you're in the system, you are trying to do something right, and it's not happening, and it's no one's fault. The sheer volume of cases. I mean, in the Supreme Court on a miscellaneous day, 80, 90 cases are being listed on one day. Can you imagine a two judge bench, 80 cases they are reading in a day? At least 8 impugned judgments, so they are reading before coming. So at least 80 impugned judgments. Can we imagine doing that much work for one day? We cannot imagine. So I mean, instead of blaming, we need to have pre litigation mediation has to be done, and we need to have very A1 trained mediators who will ensure that over where mediation can happen, where settlement can happen, the matter doesn't reach the court. It is very important. To use litigation as a measure to reach a settlement is a very wrong strategy. I mean, everyone does it, of course, but it's a very wrong strategy in the sense that you're bombarding cases in the system. People are going up till Supreme Court. Divorce cases are going up till Supreme Court, and in the Supreme Court they are settling for what? So that is something. Access to justice is something that we as a country really need to work on. I mean, we need to shift the focus of Indians from being a litigious country. You would have studied in history, legal history you're studying, I think, and they would have taught you that many historians have described Indian as very litigious people. So we need to shift that focus from being litigious to being settlement oriented. That is what I feel.
Thank you so much, ma'am. But I think my next question is for Swarnindu, sir. Sir, after this whole discussion, I've seen that a lot of changes have taken place, in the constitution or any other statutes. So many amendments, so many changes, so many viewpoints. So, what do you say to those budding lawyers and the fresh graduates? How do they adjust themselves in this scenario now?
You see, for a lawyer, for all of us as lawyers, it's not a 9 to 5 job. Please remember, it's a profession. All of us remember that in the hindsight. It's a profession. Some days we take off, some days we don't need to, don't feel like working, and we also have good days and bad days in our lives, like all other professionals do. But this is not a 9 to 5 job. You ask, like for me also, and for Pallavi also, for Akriti also, when we come back from court, suppose it's a part heard matter. When we come back from court, we are eating, we are watching television, or we are watching something, we are reading something, but still in the hindsight we are thinking about what can we argue tomorrow to have achieved the best possible result. If a question X is asked by the judge, what will be the probable answer? Then if we are in two minds, then we ask the client, "Okay, what is the factual clarity on this?" So that we are ready for everything. Every kind of bullet will comes from the court. In the court you can expect no mercy. It's one if one mistake and you are gone, and your reputation matters in the courtroom, right? You can learn from your mistakes well enough, but after a certain stage in your career, mistakes should be less and performance matters. And with so many, and your question being that with so many amendments and everything, you see, like, if one studies the Indian Constitution and gets a hang of it, first of all, you have to have a passion for the subject. It's not that you have to just cram it and give an exam tomorrow. That happens in law schools. One semester, 2 semesters constitutional law, one constitutional law, two admin law, whatever. It gets over. But for the rest of your life, if you choose to be an apex court lawyer or a lawyer in the high court, like you are doing 226 and 32, so you must be abreast with the latest developments in the field of admin law, constitutional law, the judgments which are coming, the interpretations which are being laid down, the argue. Sometimes you sit in court and hear senior advocates arguing. Those are also nothing less than classrooms. You hear a lot of arguments, you hear a lot of judgments being quoted. Sometimes you write them down, sometimes you remember. And always I believe that retention capacity is the foremost thing which you require in this profession. If you forget, then nobody forgives. So this is one thing I feel. And as budding lawyers, you see, budding lawyers must believe in one thing. And Daksha is here as a professor. She has a lot of students whom she is training. You see, as a like as a mentor in the during internships, we three of us at least, like, which we tend to do is we tend to make them believe ki, see, this is not a profession which where it's like a T20 match, things will come easy. You enter into the profession and expect to earn X amount of money from the very first month. No, it won't happen. It won't happen. It takes time, and you cannot get demotivated if you work, like I maintain, if you work hard, if you maintain that kind of learning throughout 24 into 7, or let's say 24 into 6, whatever it is, keeping yourself abreast, then you are bound to succeed. Like my senior had quoted a late senior had quoted a story, like two people, long back, there were two people in the Bombay bar. One was, like, two people were not succeeding. I'll tell you their names. Were not so successful in the Bombay bar back then. And one evening they were discussing that one of them would take up a job in a solicitor's office, and one of them would take up part-time teaching in Bombay University. One one of them became the one two of them worked hard somehow after that, and took up the opportunities that came their way. So one of them became the first Attorney General, and one became the first Chief Justice of India. So this is the story. And there are so many live examples where we meet with a dead end in a case. Like while arguing, we are like, we get bullets from that side, and we don't know, sometimes we don't know what to answer. So their presence of mind also works. That if you don't have an answer right now, rather than giving a wrong answer, let me take time. Every judge gives 1 day time, or a passover or something like that, where you can put your thoughts together and see an answer and come back a probable answer. So this is how you develop in the profession. It's more you watch and see, and you more you observe, and more you read, you get abreast with the legal, get abreast with the changes in this dynamic field. Then only you can succeed. There is no mantra otherwise that you do this XYZ things, 1 2 3 4, cram, memorize, go to the court, you tell the judge and you will get orders. It's not magic. Even Damini, there are like two of them would agree. The best of the cases get worst of the orders, and the worst cases get best of the orders. That's there, part of life.
Yes, sir. And I think all those who are watching this video or this advice will surely help them to, adjust themselves in the legal profession nowadays, because we have seen after this pandemic, very few people would join litigation or practice or join or come up with their own chambers, because they are very much worried about this pandemic, be it the financial stability or the changes that have done so far. But I think now I should ask Pallavi ma'am about this. Ma'am, what are the prominent changes that you feel should be bring in our legal system, or what are the changes that you feel that should be there?
Changes in terms of access to justice, or
Exactly, so that people can get free and fair justice.
so I feel actually there are three pronged this thing that I would want, that there should be some change. It's not really change, but I think it's more capacity building and training that I feel that is required. One, of course, is that we should, like Akriti told us that story about the FIR and how the investigation could not happen for three months. I feel we need to sensitize and train our investigating officers, because that's where the entire wheels of criminal justice actually starts. And if we don't have the IOs, or the police officers themselves who are not sensitized, and they are not even sensitive to the plight of the other person. I mean, there was someone who was telling me that just as similar as Akriti's story, some maid who was uh, who was being beaten by her husband, and so she goes to the police station, and this is in Delhi itself. She goes to the police station, and the police wala says that jab tak haddi nahi टूटेगी तब तक हम FIR नहीं लिख सकते. So I mean, can you believe that something like this coming from the police wala is, so for her it was, obviously she thought that that is how it works, but that clearly is not what it is. So we need some sort of a sensitization and training that needs to be done of the investigating officers, of the police officers. We need, I think that is where I feel the first and the most important part is that. The second I feel is that when we have our public prosecutors, I think they need to be trained. They really need to be trained, because so many of these cases we are seeing where yesterday only I think there is a judgment that has come on 372 CRPC with respect to whether or not victim can file a case against an acquittal, and there is 372 proviso that works on it. But nonetheless, they don't realize it. Just give me a 1 second. Huh?
You see, Damini, taking forward from what Akriti and Daksha said about the FIR saga and all those things, I would like to add on to it. Sorry, Pallavi, I'll just quote
No, no,
one
go ahead,
incident.
Swanindu. Go ahead, please.
The one incident which came to the fore, they are talking about maids. I'll tell you something. As lawyers, as somewhat there in the field, we have people who like to take us as mentors and get in touch with us and take career advices. So one of them, like a very recent incident, not even 30 days have passed since then. Like I was in Gujarat on my trip, and I get a call from one of those people, and that person told me that a distant brother, elder brother, had the audacity to film her while she was about to take bath, and that person was caught red-handed, right? Filming, and the phone was there. When they went to the police station, I myself spoke to the police officer. First of all, in the parents and the people who were there in the house, they were like, the case will go on for long. Some wrong ideas they get. Case will go on for long. You police will harass you. You have to go to the court every day. Your career will be finished. Your in the society where you live, You will be termed as a like a woman which with vices and all sorts of wrong things. A young girl of 21, 22 years, you understand the trauma she has gone through, that she was a person who is being filmed. Such a wrong things. It is an offense. It is not just an offense. It is an offense where the offender needs to be punished. And thereafter, when they go to the police station, what does the police say? The the video has been deleted, so there is no evidence. We can't believe your statement. And even if we recover the this case will go for long. You can settle. Now both all are lawyers here. We don't have a single provision in CRPC where police has the power to settle. What does that settlement mean? Nothing. Then we all have Lalita Kumari, Arnesh Kumar, this that coming. But when it comes to ground level implementation, it is zero. So first of all, sensitizing, as Pallavi said, the police officers needs to be trained. First of all, they should learn to behave. Second, they should learn to abide by the law. Third, be they know that they will get away with the system. They should not be they should not be getting away. They should be punished. Third, the family members within the four corners of some, they need to be supportive as well when you try to report a crime. And this wrong idea, and because of the wrong ideas which are being portrayed by the investigating authorities and the state, this is what is happening. Like a normal person going to register an FIR has to sit from 11 o'clock. Suppose he goes at 10 o'clock in the morning, he has to sit at 7 o'clock in the night and fight his way through. The police relents an FIR, and then when you tell them we will go under 156.3, then they will start panicking a bit, and you make them speak to higher. Every person does not have an access to higher officials. I'm like, why do you need? The law says you must register an FIR, and you don't register an FIR, and the police is not taken to task. First, there should be robust training for this. Anyway.
So Pallavi ma'am, please continue.
Oh, sorry for that, Damini. So I was on like Swarnendu said. Of course, I think the sensitization of investigating officers is extremely important. The second, I feel the public prosecutors, they require to be trained and immensely slow. So especially as far as looking at the manner in which they do their cross examination, the manner in which they conduct themselves. I think there's so much that needs to be done. Somewhere that training is lacking, and specifically when we look at crime against women, we see that is where a lot of times with the delay that happens, the victim will then go ahead and recall her statement, and the case will be settled and things like that, which of course, like Sonendu said, there is no provision in CRPC of settlement, but nonetheless this is what is happening. And the third and most important thing, I think, with respect to access to justice, I still feel that even though the judiciary is actually putting in their heart and soul, but there is still there is still a lot that is desired. Even if the higher judiciary is actually putting in a lot of effort, I think the lower judiciary still lacks in so many ways. We are able to do a good job maybe in Delhi NCR, but when we go to distant towns, we see that the kind of judges who are there, the kind of work that they are doing, I think there is a lot that needs to be done over there, and they need to be trained more, most importantly, because the kind of questions that they pose to the victims itself sometimes makes you shudder to the extent that how is it that somebody like somebody who's at a place which is a place of power, on a podium, so to say, can actually question such things. And And these or the kind of judgments that we read sometimes of the lower court judiciary, I think that itself shows the lack of sensitivity. And I think that is where I feel that these three institutions really are required to be trained, so that we see something effective coming out of it. It's all there. The infrastructure is there, but it is not working.
Thank you so much for your response, ma'am. So I would just like to announce something that Swadendu sir has to leave in between. So, sir, over to you, and then we can just proceed with our panel discussion.
Yeah, sorry that I have to leave it between. There is some professional commitment anyway. So it was a enriching discussion, and I truly believe that going forward in the next few years, in the next decade, or perhaps we would be improving with the safety and security of our with safety and security of the insiders, let alone the outsiders. One, two, we will have more robust system with respect to the more robust legal system with all the, as Pallavi mentioned, we have all the infrastructures in place. The infrastructure should be first of all developed in the trial courts where the burden of litigation falls, as well as the tribunals. Only creation of tribunals won't help. You have to man them. You have to have people who will handle the registry properly. Then the benches, ensuring that the benches are functioning. Now you see, with the Supreme Court came hard at the central government with the DRT and DRATs not functioning and giving the temporary jurisdiction to the High Court. Now this anathema, like shifting from one place to another, High Courts taking up things under 226. These are things you have to lessen the burden of the court. We have to work towards the lessening of the burden of the courts, and we as lawyers we as lawyers have the utmost duty and rise above the occasion to advise the clients. You see, this is the way forward. You have to carve out this way. Unnecessary fighting won't fetch you much, and unnecessary filings, unnecessary going forward with a lot of litigation, appeals, revisions. Of course, when it is required, it is required. When the other side is adamant, you can't help it. But when you have a possible resolution, when you can see that a possible resolution is coming forth, then you have a possible resolution which is coming forth, and you have to make, and the clients also have to believe there is no point in fighting. Fighting takes 20, 25 years. But what is the net result? We as lawyers will earn. But what you lose time and energy, right? So, and our constitution being so vibrant, so lively, and everything has our constitution and the constitutionalism in the country is ever adaptive to every robust change which happens in the society. And I look forward, and I sincerely hope that the society will be more adaptive and to the changes. The ceilings would be broken, and we will work towards, with, as a society, and march forward for the development of the nation, which is of prime importance.
Thank you so much, sir. Thank you so much for your presence,
Thank
and
you.
happy Republic Day once again.
Happy Republic Day.
Thank you, sir.
Thank you, sir.
Thank you, Pallavi. Thank you, Akriti. Thank you, Daksha.
Bye, Swanindu. All the best. Thank you so
Thank
much.
you.
Bye.
Thank you.
Thank you,
Yes,
sir.
Thanks, Amindu.
Thank you. Bye.
Okay. So moving forward with our panel discussion, I think the next question is going to be very, very important. And I should ask this question to Professor Daksha because she specializes in constitutional law. So, ma'am, would really like to know that why can't the jurisdiction of High Court can come under Article 32, even though they have much more capacity of issuing writs. But we only talk about Supreme Court when it comes to Article 32. So we would really like to understand.
Thank you, Damini, for this question. I would first of all like to correct here that my specialization is not constitutional law. My specialization is international law. But still, like, I have the privilege, and Bennett University has given me this privilege, and I would say it is a responsibility of this nature to teach constitutional law to the students. So, talking about Article 32 and Article 226. So, of course, we have distinctions lying within the Constitution itself about the nature and working of these articles. And I believe that these articles should not be mixed together, because we know that the courts are already overburdened, and especially when it comes to the working of the apex court, we witness that courts are already overburdened, and if the powers which are lying there with 226 are further mixed with the powers which are there with article 32, so then it would lead to a chaotic situation, which would, like, which can't find a redress anywhere. So it is in a good spirit that article 32 should be treated differently and article 226 should be treated differently. So I even had the privilege to practice before the apex court and high court and other subordinates courts before joining Bennett. So I believe and I have seen the working of the courts very closely. So typically, if we see the working of the apex court, and correct me if I'm wrong, because I'm making this statement in the presence of two eminent lady lawyers of the Supreme Court. So 80 to 85% of the work which is there with the Supreme Court is that of the nature of SLPs. Rest 10%, if you count, it comes with the writ jurisdiction of the Supreme Court, that is under Article 32. And other 5% you can count other petitions like transfer petitions and so on and so forth. So keeping again this nature and division of work of the apex court in mind, uh, I come to the conclusion that there is, of course, no need to mix the powers of 226 with that of 32. It is good that 220 under 226 we have wider powers given to the constitutional courts of the country for the issuance of the writ, and such power is not required under 32, keeping in mind the nature of work which is coming before the apex court, because most of the petitions are that of the nature of SLPs, special leave petitions under article 136 of the constitution. So when we see that 85% of the work is with respect to SLP, so hardly it matters that whether this power of 226 should be diverted to 32. Again, when we see the working of the constitutional courts with immense happiness, I note that the working is more in the practical style. For instance, that when there is a requirement for introduction and expansion of the writ jurisdiction, they do as per their needs. I remember senior advocate Salman Khurshid sir talking about the working of writ jurisdiction of the constitutional courts, and he specifically stated that now if we dwell into the concept of mandamus, it has been expensive in nature, for the fact that a continuing mandamus by the nature has been introduced in the working of the apex court as well as the high courts in India. So now you see that when we talk about these aspects of continuing mandamus, I never had the opportunity to study it about in any of the commentaries of the constitution or anywhere else. This is something which I learned from the court practice. So accordingly, like, I would just like to conclude this by saying that our constitution is a living document with a progressive nature, and it is the court which is responsible for evolving this document further by way of judicial activism, suiting to the needs of the time and the society. Thank you.
Thank you for the response, ma'am. But would really like to ask Pallavi ma'am and Akriti ma'am if both of them would like to add on something to this question.
Akriti, would you like to take that?
I'll just add one thing that I mean, as Daksha ma'am has said that, you know, it's different when you read the law and it's different when you practice it. It is so, the difference is so vast, and I always tell students also that, I mean, it's one thing to understand a proposition of law, it is one thing to explain it to another person in simple words. Because when you are standing in front of the court, especially in a miscellaneous day, you will get an audience of maximum 2 minutes. In 2 minutes, how much ever fat, how much ever thick your file is, you have to explain it to the judge in 2 minutes, and you have to give him something on which he is ready to give you an order. So, I mean, that is something that you learn only in practice. And so that is why you have to read so extensively. And so that you are able, you are, the grasp of the subject, the grasp of the brief is such that you are able to, you cannot explain something that you don't know fully in simple terms. It's not possible. Try reading up a concept which you've just read and try summarizing it in 2 lines. It's not possible. Until and unless you know in and out of the concept, you cannot do it. So that is why there's so much of hard work required, and that is why you learn so much while, practicing, because you're putting it into function and you're putting it in simpler terms.
Pallavi ma'am, would you like to add on something?
I actually, that question was quite intriguing where you said that, the high courts obviously have more power. So there was a reason why the founding fathers actually made it like that. And obviously, increasingly, like Akriti said and Daksha ma'am said, we've noticed that increasingly Supreme Court is getting burdened. I mean, what are we looking at? Transfer petitions which are coming every single day for matrimonial cases. I mean, 80% of these transfer petitions are matrimonial cases. You've got custody battles which are brought right up to the Supreme Court, where even the honorable judges say that why is it that you are still fighting here? It's just one way or the other, and it is for the benefit of your own child. Then why is it that you're still fighting it over here? But out and out they will do it. So where we feel that adjudication is required on specific questions of law because there are so many of them pending, like for instance restitution of conjugal right. I feel that that is just a colonial legacy which is still there. Somebody, or if there is not so much of burden on the honorable Supreme Court, I'm sure they'll be able to decide it one way or the other in terms of whether it should survive or not, just as they decided on triple talaq, just as they decided on adultery. This is a very, very important concept which needs to be decided. Why is it that increasingly we are noticing that and Akriti and I'm sure we've all across India have been facing this. Like for instance, in the High Court, we've only had the recent filings that are being dealt with. A lot of previous matters are not getting dealt with, or and these are litigations which are important to the citizens. This is why they've actually come to the High Court, or this is why they've come to the Supreme Court. But there are alternative ways which they are not looking at, and the whole purpose of sorting things out, and what is interesting is Akriti must have noticed this is that the honorable judges in the Supreme Court have now started to say that if there is a mediation that needs to be done, not necessary that you should have it done in the Supreme Court mediation cell. They say, why don't you go to the lower court? There is an equally efficient mediation system there. Try and do it over there instead of coming to Supreme Court and burdening us with it. That's just about mediation. Similarly, they say High Court is equipped. Why do you have to travel all the way to the Supreme Court? There has to be finality to litigation at some level. Not necessary that just because there is a 136 right which is given to you, you just go and exercise it. And interestingly, against most of the interim orders. I mean, this is the trend that we've been seeing, Akriti, that because there is very less disposal that's happening since the lockdown has happened. It is only against interim orders, and I'm guilty of it, but I also have to run an office. But nonetheless, it is increasingly against interim orders that we are coming here. So it's got nothing that the judiciary is itself getting overburdened. We can't really help it, and it is why, because the clients are impatient. They are impatient because disposal is not happening in the high courts, and the interim orders, one after the other, if they've been waiting for 2 years for any adjudication to happen, which has not really happened, their rights are not decided, they have nothing else left but to come and challenge an interim order. So if you look at it subjectively, you'll realize that time is, or rather time is something that we all are very protective of, our own time in this world. And especially with the kind of pandemic that is going on, all of us are also worried about so many other things that are adherent to it. As a result of which, I feel that clients are also becoming very difficult to handle, and no matter how often we try to give them the correct advice which we feel is the right thing to do, down the street they'll find at least five others who will agree with what they are saying, and they'll be very willing to file those matters for them. I may say no, Akriti may say no, but there'll be third or fourth person who will say yes, I'm going to file it, I'm going to take it. So so as professionals also, there is nothing that bars us, uh, or it's except for our own ethics maybe, nothing that stops us from doing what the client is asking us to do. And in that manner, I think we end up burdening the judiciary in so many ways. And therefore, this whole mediation bill, which is going to be hopefully passed in a little more better manner, and pre-litigation mediation, I mean, very recently, at least for the past 2 years, whatever cases that are coming in, I have been referring all of them where I feel these are family disputes to Samadhan, which is the Delhi High Court Pre-Litigation Mediation Center. I think they do a fabulous job, and at least 80% of matters are getting resolved. Trained mediators, everybody has to pay in order to get those services, so people are actually serious about it. And three, because of the settlement agreements that are coming out of it, I feel that the rights are getting stabilized, and therefore the litigation is getting reduced in that sense. Also, because I think people have started to realize that litigation anyway is a costly affair. One, it's costly, it's time consuming, it's going to go on for 5 years, 6 years, 10 years. I mean, I have my father's case which is going on for 15 years, and now it's pending in Supreme Court. So you can't, which was one of the reasons why I became a lawyer. But nonetheless, so this is how it goes. There has to be a stop sign somewhere, and I think as lawyers, no matter how many times we'll try and do that, it would not really materialize unless and until the citizens are sensitized for it. So yeah, 32 and 226, they should always be distinct powers, and not one institution should be overburdened with the other. Yeah.
One small point that I'd like to add before you ask the next question, that sometimes 226 has been given a wider power because sometimes the High Court is better equipped to deal with those kind of questions. Sometimes the violation of the rights is such that it's a state specific problem. And in that sense, if the Supreme Court from the center starts conducting a fact finding inquiry sitting here, it's really not feasible. For instance, you would remember sometime, I think 3, 4 years ago, there was an acute water shortage in Himachal Pradesh. And the High Court dealt with it beautifully. They decided that this much water is going to come into the state, this much water is going to be dispensed in this area. The entire process will be videographed. Do you think, say, Supreme Court sitting here could have actually, monitored the process so well? I mean, it would have taken so much more resources to do that. The order will get communicated, then some person from here will be appointed to go there. So it sometimes the high courts are much, much better equipped, and they are in the center of the issue, and they can decide. And as Pallavi and Daksha ma'am have both said, the Supreme Court was never envisaged. If you see the Constitution, if you read the Constitution, Supreme Court was never envisaged as a court of appeal. It was envisaged to decide only the questions of laws, much closer to the US Supreme Court, which only decides on propositions of law. But now, by way of 136 jurisdiction being misused, now 90% work that the Supreme Court is doing is appeal work. Actually, 136 is nothing but everyone is, it's a kind of appeal. It's no longer extraordinary. Every ordinary order is being challenged under 136. So I mean, it has really lost its extraordinary sense in that way. So I mean, that is why it is very important that 226 and 32 remain different, and because the state specific problems should be sorted by at the state level. I mean, if everything, as Pallavi said, if everything starts coming to the Supreme Court, might as well have one court only. Why to have three, four courts?
So I think with this, I'm done with all the questions that I had framed for you people. But let me just end this session on a very polite way. So I'm going to ask you all to please present a sort of ending note for the people who are actually watching with us on YouTube, because the event is being live streamed. So any sort of advice for the people on this Republic Day, any sort of thing for them, or any prominent change that you feel should be bring about in our legal system. We're going to
Um,
start with Advocate Pallavi.
Oh no, Akriti is actually
Sorry,
saying it. So
I'm so
let's
sorry,
just
I
start,
missed it.
go
Yeah.
that
alphabetically this time.
Okay.
I mean, the The only thing that I'd like to say, I mean, as a student of law or as a common citizen, there's one phrase called fraternity in our preamble. I think in the 21st century, we are lacking a lot of that in this country. Every day we are hearing about, you know, I mean, it cringes when I read about these instances, religion based crimes, caste based crimes. We are in the 21st century now, and it is time to really put meaning to this word fraternity. We have to, if as a nation we have to succeed, we have to fraternize, we have to believe in brotherhood, and we have to march together as a country, because I mean unity is all our strength. And if we, we can fight with each other and destroy the strength of our country, or we can unite. So fraternity is something, law student or not, every common citizen, I feel that this Republic Day we should make it a motto that this year we will take a pledge to fraternize and be with each other like brothers and sisters.
Okay, Professor Daksha.
My message is simply to be in one line. That's let's live with the spirit of Constitution of India. Give Constitution of India place in everyone's heart. And if we live with this spirit, I don't think so that any matter has the power to get politicized. So let's come together and live with the spirit of Constitution of India. Thank you. Jai Hind.
Thank you, ma'am. Pallavi, ma'am. Finally, the P is here.
Uh-huh. Thank you, Damni. Uh, my it's not a message really, it's a request that every time that you're about to form an opinion about anything in life, about any person, about any incident, about any news, make an informative opinion and do not go by WhatsApp University. I feel it's important that we are all educated people, and for anything that's happening in the country, it's important that we get into the depth of it. I think with all the lockdowns and all, we have a lot of time in our hand to research on things when we are forming an opinion. It's important that we research on it and then form an educated opinion about a thing, and not just go ahead and start arguing without even understanding what the problem is. I feel that will at least cut down the adversarial nature that unfortunately all of us sort of are moving towards. And also the other very important message is, I don't know, it doesn't apply to everybody, but just be kind to people, not just on social media, but also personally. Yeah, that's about it.
So thank you so much everyone for these kind words, and very informative kind of panel discussion it was. And I hope the people who are watching it on YouTube, I must say that the discussion was all about the changes that have done in the constitution so far, the issues that the people are dealing with, and as an advocates or the professors, what they have dealt with, their own experience, the information they have presented before you people was just to make you aware as to what is happening or what has happened and what should be done. So do not make any opinion based on this panel discussion, just do your own research. Yeah, so I should say this because what people do right now is they just comment, because we have seen already that people have started commenting, and because of that we had to restrict the comment section. So it's a huge it's a humble request to you people to please don't make what do you call it, a sort of opinion based on this panel discussion, because they were personalized opinions. So you should have your personal opinion, but not based on the opinions of the others. So with this we end up our panel discussion, and I hand over the mic to Upasna for a vote of thanks.
So, I, on the behalf of the entire Legal File team, like to extend my heartfelt gratitude to all the panelists for sharing their time for the panel discussion. Through this panel discussion, we were completely able to understand that what is the constitution importance, like how constitution is important for us, and how it is still relevant in the present scenario.
I think we've lost her, right? Yeah, so let me just continue this. That thank you so much to each one of you for sparing your time on this Republic Day. The panel discussion was really very informative. Like the cases you mentioned, your own personal cases that you have dealt, the experiences that you have dealt with. that really made me understood that what sort of issues still people are facing, even though we have dealt with a lot of amendments with the respect to the constitution, be it the equality between men and women, be it the free and fair justice that needs to be given to the people, be it any sort of issue. We've really realized that still there's a far way to go. And I think these sort of panel discussions should be organized, I think, every month, so that people can understand, based on your experience, what is going on in the society, because it's very easy to form opinion based on the posts that people post on LinkedIn. But it's okay to connect with people like you, it's okay to watch you people, it's okay to talk to you people about the issues that you people really face. Just like Swanendu sir said, that youth nowadays, they are very much worried about joining litigation or practice after this pandemic. But the changes that have been done for them, for the youth, for the coming generation, so that they can just adjust themselves in this sort of sphere where a lot of changes have been introduced. So I think this is what the panel discussion was all about. And I must say that you people are very busy people, I must say. I had to talk to you people, request you people to please agree for this, and you people did that. Thank you so much. And I hope the viewers who are watching this video on YouTube will surely like this. Thank you so much to each one of you for, accepting my invitation for this panel discussion.
Thank you so
Thank you
much.
for having us.
Thank
Thank
you.
you.
Thank you
Thank
for
you.
Thank you so
organizing
much.
this scintillating event.
Thank you
Thanks.
so much.
Happy
That's
Republic Day.
Thank
that
Happy
we are done.
Republic Day.
Okay, thank you.
Bye.
Bye bye, guys.